Well, morning, everybody. Bill O'Leary coming to you live here on Thursday. This is Thirsty Thursday for those that don't know. Bill O'Leary from a lawyer from Legacy Planning Law Group. I do estate planning and elder law and probate and estate administration. So, Thirsty Thursday, what is this all about? So every Thursday I go live for about 7 to 10 minutes, and I sort of talk about a different topic that we sort of see in our law practice that deals with wills and trust, or some elder care planning and so forth. A different topic each week. So we call it Thirsty Thursday because I like to say if you're thirsting for knowledge, you've come to the right place. So let's just jump right in. What today's topic is, we get this question a lot. Does having a will, a last will and testament, does having a will avoid probate? The answer is no. The answer is no. Having a will in Florida, having a will does not ensure that your assets avoid probate upon your death. In fact, in many situations, it's almost going to guarantee probate. Okay. So now, so let's talk about a will. In fact, the very nature of a will sort of means probate. In your mind, sort of, you can associate the two terms, a will and probate. What a will does is it distributes at your death your probate assets to the correct beneficiaries. Assets that are in a deceased person's own name are assets that go through probate in Florida. So your personal representative, also known as the executor under the will, but we now use the term personal representative, must go to probate court before distributing those assets to your heirs. Okay? So again, what your will does is it lays out where your probate assets are distributed at your death. So in other words, who gets what? That's what a will does. It lays out who gets what. But the probate court has to approve the will first before the estate can be distributed. And what's the big deal about probate? Well, the two principal problems that we see all the time in probate, a family comes into the office whose loved one just passed away and whose loved one maybe did not plan as well as they could, and maybe they died without a will, or even if they did have a will in place when they died. And the family is saddened to discover, oh, well, then things are not going to be smooth and easy. We're stuck in probate. Even though, let's say, mom or dad had a will, we're stuck in probate. What are the problems? Number one, probate takes a long time. In fact, the average in my experience is anywhere between 9 and 15 months. We've got some that are longer than that, where the family is sort of stuck. It sort of represents a period of time during which the estate is sort of frozen in time. So it takes a long time. It's often sort of a frustrating experience. Number one, takes a long time. Number two, it's expensive, and by far the largest expense comes into play because, at least in Florida, in most every probate, a lawyer has to be involved in the probate case. Has to be hired by the executor or personal representative to handle it. And so, as such, when the lawyer's involved, they get paid for their service. They get paid a fee, and that fee, under the law in Florida, can be based on a percentage of the value of the estate, between 3 and 5%. That can go as a fee to the lawyer, depending on the nature of the estate and the assets and so forth. So, it takes a long time and it's expensive. So, if you want to avoid bogging your family down in the probate court, it requires more than just having a will. Look, having a will is better than nothing at all. It's better than the back of a napkin, because if all you have is the back of a napkin, or sort of a conversation you had at the dinner table where you told people what you wanted, which is really nothing at all down in writing. Well, guess who comes in and answers important questions for your family in terms of who gets your stuff, what they get, when they get it, how they get it. If you don't have a will, who answers those questions? The government, the state. So having a will allows you to answer those questions. So it's better than nothing at all. It's a good start, but it's just that. It's a start. It's not good enough. Okay? So again, it requires having more than just a will if you want to avoid sort of sticking your family with probate. There are basically three different ways where you can avoid that probate mess and still retain control over your assets. The first is with what's known as a living trust. A living trust is sort of designed to allow your assets to automatically and easily pass to your beneficiaries at your death without them having to go through probate. And the reason why a living trust works so well to avoid sticking them in that court process and with that mess is that the assets really at your death are no longer considered yours when you die. They're instead considered owned by the trust. Whereas if you have a will and that's all you have, then at the moment of your death, your assets are still considered yours, And so if an asset is still considered yours when you die, it has to go through probate. But if it's not considered yours anymore, as in a case with a living trust, where it's not owned by you, but it's owned by the trust, if it's not considered yours anymore, then it avoids probate. So that's the first way, a living trust. A second way is what's known as joint ownership with right of survivorship. So if you own an asset jointly with someone else and it has what's called right of survivorship as part of that joint ownership, a magic word, right of survivorship, the asset will automatically pass at your death to the surviving joint owner. This form of ownership, you see, is also sometimes referred to as joint tenancy with right of survivorship. So look, you can own an asset jointly with your spouse, or it doesn't necessarily have to be with your spouse. You can own it with somebody else, a non-spouse, like let's say a child or a sibling or parent or whatnot. So let's say you own a financial account jointly with someone else. At your death, that account will pass straight away to the surviving joint owner without having to go through probate. So you may say, oh, that's pretty good, pretty nifty, pretty easy. So the question then you have to ask yourself is that smart? Is that a good idea? Is it smart, let's say, to add family members as a joint owner on the house or maybe on a financial account? Is that smart? Absolutely not. Absolutely not. Look, I'm not a fan at all of sort of burying your head in the sand and relying on joint ownership as a form of estate plan. Reason being, there are a lot of problems or limitations with joint ownership. So let me just mention two of them. One, an asset that is held in joint ownership with right of survivorship is immediately subject to the claims of each joint owner's creditors. So think you add your adult son to a financial account as a joint owner, right of survivorship, okay? And your son then gets into a car accident, it's driving recklessly, and it's their fault, and now there's a lawsuit. Well, guess what asset they may come after? That joint account that you added your son to. You take on unnecessary risk by doing that. Problem number one. Problem number two is one of the joint owners can what's called sever that joint tenancy or break it apart by selling or giving away their joint ownership interest without getting your consent or approval. You think you'd be happy with that outcome? Probably not. There's a much better way than this joint ownership with right of survivorship, a much better way to avoid probate, not sticking your family in that mess. And again, that's with a living trust, what I just talked about a couple minutes ago, a living trust. And then the third way you can not stick your family with that probate mess is just simply to designate them as beneficiaries, let's say, of a financial account. So things like a checking account, savings account, maybe retirement account, even things like life insurance, annuities. You can name a beneficiary. But although that may sound sort of simple, quick, and dirty, is that the best way? Is that the smart thing to do? Wanting to protect their inheritance. What if you want to protect their inheritance from what? Well, maybe if they ever get divorced, or maybe they get into that car accident. What if you want to protect that? Will that inheritance be protected for your child if they're just named as a beneficiary on a financial account and they get the money straight away, deposited into their bank account, let's say? Absolutely not. It won't be protected. It'll be at risk. It'll be exposed to that divorce or car accident. So in contrast, using a living trust, again, I come back to the living trust as a great solution. It's a great way to protect your child's inheritance, and it can be done in a way where your child still has access to the money. Yep, still have access to the money. You can't do this just by naming the child as an outright beneficiary on the financial account. A living trust is a much better way. So, hopefully this has helped. If you'd like to learn a little bit more about whether a will avoids probate, and maybe would like to know how we can help, we would love to talk to you. We really would. We make it very easy for you by inviting you to schedule a free 15-minute, we call it a discovery phone call. You can do it on the Book Now button on our Facebook page, or just Google us, Legacy Planning Law Group. Okay. And again, that 15-minute call is a way to sort of introduce to each other and for us to get a feel for what your concern is, and that call is complimentary. Okay. So hey, if again, just trying to get the word out. So I hope you've enjoyed this talk on how a living will does or does not avoid probate. In fact, whether a will and having a will avoids probate, and of course the answer is no. So I plan on giving another talk next Thursday as part of our Thirsty Thursday series. So again, if you're thirsting for knowledge, you've come to the right place. So on behalf of everybody here, on behalf of Team Legacy, the 4 great ladies I work with, I want you to go make it a great day and make it a better world.